Okay, so actually we'd like to withdraw Amendment 1, and then I'll speak in terms of Amendments 2, 3 and 4. Effectively what we're trying to do, just a general remark while I have the time. Obviously, to be clear, we're in favour of hate crime legislation, but we want to see it done correctly. We want to ensure that there's no issues in terms of basic issues of civil liberties effectively here. So that's what we're aiming to achieve with our amendments. In particular here, what we're substituting, instead of hatred, instead of an action by someone or speech by someone causing hatred in the mind of another, instead to be more specific and replacing it with intimidation, hostility or discrimination. In other words, to specify that this is something that generates in another person something that could have an actual victim as a consequence of that, an action that would result from that. Something that we're eager to avoid, and we'll come to this maybe a more substantive discussion later on in relation to Amendment 6, but it is effectively the creation of thought crimes. So we want to see that there is definite negative consequences as a result of the hate speech that we're talking about here. So that's the purpose of those 3 amendments.
I'll ask Ciaran Corley, and I thank the deputies for their amendments, which I understand were discussed at length, and I note the deputy has withdrawn amendment number 1. Can I just say, in relation to it, the Attorney General has further advised with regard to rules of statutory interpretation, and the Supreme Court has consistently held that statutory provisions should be given a construction that reflects the plain intention of the Oireachtas, and this should be determined by having regard to the ordinary and natural meaning of words. And in determining the meaning of any word or phrase in a statute, the first question to ask is, what is the natural or ordinary meaning of the word or phrase in its context and in the statute? The definition of hatred as currently set out in the bill represents the word's ordinary meaning and everyday meaning, and is established in terms of the statute book as evidenced by the Prohibition of Incitement to Hatred Act of 1989. So it is, and in relation to that, it is worth noting that in UK jurisdictions which have an offence of stirring up hatred, that is incitement or hate speech, hatred is not defined except to make it referable to certain characteristics, as is in the case in our bill. Similarly, in the European Council framework decision to which this legislation has to align, hatred is only defined in the context of making it referable to certain characteristics. So in relation to hate crime offences in other jurisdictions, these offences are aggravated by different terms such as hostility in Northern Ireland, England and Wales, malice and ill will in Scotland, and in all of these cases the term hostility or malice and ill will are not defined in relevant statutes. And on this basis, the Attorney General has advised against any amendments to the bill with regard to the meaning of hatred, and I agree with this advice. Hatred is a concept that is well understood by our courts, and I believe that it is fair and correct for us to place our faith in the criminal justice professionals whose duty it is to interpret and apply legislation decided by the Oireachtas. In relation to the incitement of violence or hatred offence in section 7 of the bill, the proposal to amend the wording of the offence to remove all reference to hatred and instead, as I say, incitement of violence or intimidation, hostility or discrimination. I must remind the deputies that transposition into Irish law of the European Council framework decision on combating certain forms and expression of racism and xenophobia is a key aim of this bill, as set out in the long title. An offence of incitement to hatred is a requirement under this framework, and if not set out in this manner in the text of the offence, the requirements of the framework decision are not fulfilled, and for those reasons I can't agree to the amendments. Thank you.
Murphy, shut.
Yeah, so in terms of Amendment 1, we take the point in terms of the case law establishing what hatred means. But in relation to 2, 3 and 4, right, so just to explain again what we're doing. Currently we are saying someone's guilty of an offence if they communicate material to the public, behaves in a public manner, in a manner that is likely to, quote, incite violence or hatred, end quote, against a person or a group of persons. And clearly, of course, we agree it should be an offence to behave in such a manner that you're likely to incite violence against a person. But we think it's better to specify actual negative consequences for someone, thereby replacing hatred with intimidation, hostility or discrimination. That in and of itself causing someone else to have hatred shouldn't in and of itself be sufficient to establish a crime. and therefore, we need to be more specific about the negative consequences we're talking about. And to be clear, I'm not at all downplaying those negative consequences of hate speech which exists, of the violence, the intimidation, and so on that flows from that. But therefore, we need to be explicit in the legislation in relation to that.
Bona fides in this, and he's certainly not in any way trying to downplay what is hatred. Look, in terms of this comes from European Council framework decision. They have set out what the requirement is to meet that framework decision, and if we deviate from the wording as we've used in the bill, we'd no longer be in compliance with the framework decision as fulfilled. And I think for other reasons as set out earlier, but also this particular reason, I'm not in a position to accept the Deputy's amendments.
Deputy? No. Okay, so how stands amendment number 2?
Pressed.
So amendment number 2 has been pressed. Amendment number 1 has been drawn. So na chakti atá hívne keshta abrigi tá. Na chakti atá na gwina abrigi níl. Is tó gwyl an chest culture. Moving on to amendment number 3. It has already been discussed. So how stands that amendment? So amendment number 3 has been pressed. Na chakti atá Sunday keshta abrigi tá. Garmagat. Agus na chakti atá na gwina abrigi níl. Stoha gwyl an ceist culture. Agus Ivra Cahar, already discussed with 1. How stands that amendment?
Pressed.
Pressed. So the amendment number 4 has been pressed. Agus see an ceist ná the chakti atá Sunday keshta abrigi tá.
Tá.
The chakti atá na gwina abrigi níl. Stoha gwyl an ceist culture. So now moving on to amendment number 5, and 5 arises out of committee proceedings, and amendment 5 and 7 are related and will be discussed together. Deputy Murphy.
Yeah, so the amendment here is to remove as a defence for hate speech material that something is a reasonable and genuine contribution to religious discourse. Obviously, a lot of very positive messages of solidarity, of support, of charity are carried out as part of religious discourse. Many other messages are carried out, theological points and so on, under the guise of religious discourse. All that, of course, is absolutely fine, and the state should protect all of that religious speech and the right of people to propagate their religion. I'm for a secular society. People often focus on one part of that, which is that the state doesn't support any religion, but another important part is that actually the state defends the right of those who are religious to put forward and propagate their religious views. But it also is the case that a certain portion of hate speech within our society, particularly homophobic, transphobic, sexist hate speech, is sometimes put forward under the guise of being a contribution to religious discourse. And fundamentally, I don't think that should be a defence. Hate speech is hate speech, even if the person involved says, "Oh no, it's my, deeply held religious view that gay people are sinners, and therefore it's appropriate for me to incite violence against them." Fundamentally, that should not be a defence, and on that grounds, we seek the deletion of the religious ground as a defence.
Thank you, Alaska and Corlin. I thank Deputies Murphy, Smith, Boyd, Barrett and Kenny for their proposed amendments. They propose removing the defence of a reasonable and genuine contribution to religious discourse and expanding on the provisions of Section 11, which provide protection for freedom of expression to include the right to express ideas which shock, offend or disturb. I must point out in this regard that the freedom to express and practice religion is protected under the Irish Constitution and under the European Convention on Human Rights. Accordingly, religion is considered to merit a similar level of protection as literary, artistic, political, scientific or academic discourse. Under the provisions of the bill, it will be important for persons accused of these offences to have an opportunity to defend themselves if they believe what they were saying was reasonable. For example, if a person is writing an academic paper on the portrayal of a race in literature over time, and they include problematic quotes from older pieces of literature, this paper would be considered a reasonable contribution to academic and literary discourse. It would be a matter for a court to determine if the use of this defence is permissible in the circumstances of any individual case. Furthermore, these defences were examined at length by the Attorney-General, and I am advised that they are in order as currently drafted. Similarly, the freedom of expression provision in Section 11 has been carefully drafted in consultation with the Office of the Attorney-General and clarifies that for the purpose of this part of this bill, a communication is not taken to incite violence or hatred solely on the basis that it involves discussion or criticism of matters relating to a protected characteristic. This is important as it sets a clear bar for the courts to assist them in determining what is and what is not incitement to violence or hatred. It is important to stress that this section was expressly drafted in line with the European Convention on Human Rights, and this section does not create a defence for persons who are accused of incitement to violence or hatred, and therefore cannot be exploited or abused by people who incite hatred to try to avoid a conviction. It is only the most severe types of speech which constitute incitement to violence or hatred that will be criminalised under this bill. Discussion of protected characteristics, including criticism of matters relating to protected characteristics, is not a crime unless it crosses the line into incitement to violence or hatred. This remains a high bar and isn't something that people will just fall into. This provision under Section 11 is set out as it stands to put beyond doubt that there will not be an offence to hold and express particular views unless this very high bar is cleared. Deputies Murphy, Smith, Boyd, Barrett and Kenny seek to expand this provision to include a general principle that the right applies to the expression of information or ideas that offend or shock or disturb. This was considered by my department, and the Attorney-General's view was sought on this issue. The legal advice is clear. These words do not capture all aspects of freedom of expression that might have a detrimental effect on a victim without reaching the standard required for an incitement of violence or hatred offence. By singling out such material in particular, we run the risk of inference that other aspects of freedom of expression, such as the right to dislike a person, for example, are not protected. The inclusion of a provision worded in this way could result in the unintended consequence of creating a defence argument that highly offensive or shocking forms of expression that may otherwise be an offence under this part will be protected under this section. There is a possibility that the provision of this nature could be abused by a person convicted of incitement to avoid a conviction which would otherwise be entirely unwarranted. Accordingly, I cannot agree with these amendments.
Yeah, 5 and 7.
5 and 7, grand. Okay, I'll speak to 7 there. Yeah, I think I've made the points on 5, and I actually think that the points that the Minister makes about the high bar that's needed, like...
Just, sorry,
Yep.
you stop the clock for a minute.
You're
The two amendments are grouped,
Yeah.
so you had 7 minutes, and then you have 2,
Yeah,
and then you
yeah,
have
don't
an
worry.
option of another 2.
Okay,
Yeah.
thanks a lot. Yeah, so, see, the points about the high bar, in my opinion, they're arguments not to have the religious defence, because there is a high bar. Most, you know what I mean, regular religious discourse is not going to fall into the realm of hate speech. It only would do so potentially in a circumstance where it crosses a very high bar, i.e. it's quite hateful, like that's the context. And that's the only circumstance there where such a potential defence would come into play, and therefore I argue we don't need such a defence, that it isn't appropriate to have very hateful speech crossing a very high bar, then being subject to a defence of it being a reasonable and genuine contribution to religious discourse. Yeah, I think it's important. I think there is a balance here in terms of the question of freedom of speech and the criminalising of hate speech. Again, we're in favour of taking action against hate speech, but we think it is a very, very important issue of defending the right to freedom of expression, and therefore, it clearly is good practice to insert an explicit reference to Article 10 of the European Convention on Human Rights, including the general principle that the right applies to the expression of information or ideas that offend, shock or disturb. That simply goes into the legislation, like the Minister has made the point about, it'll be up to the judges will interpret this and so on, yes, but therefore it's appropriate that when the judges are interpreting this legislation, which obviously, this area is a sensitive area, it has the potential to infringe in terms of civil liberties, that explicitly there is a reference to the European Convention on Human Rights and the right to freedom of expression.
Thank Thank you, Last Carla. Look, I think I've set out clearly my position in relation to it. Look, I hear the Deputy's comments, but unfortunately I'm not in a position to agree.
Ceachta.
Yeah. So it's freedom of expression in operation. Either freedom to express and the freedom not to agree, which is true. Yeah, I mean, do you accept on any general level that there is a risk here, that we're engaged in a sensitive, risky area which touches on the right to freedom of expression, and that while it is appropriate that hate speech, hate crime is dealt with, that it's very, very important that the right to freedom of expression is defended. And ironically, it's kind of related to, we're getting rid of, or we're attempting to get rid of, a specific defence for religious discourse, because we don't see the grounds on which religion in particular should have a specific defence. But in general, we're just saying that this is important. This needs to be taken into account, that people have the right to freedom of expression, and therefore there is a balancing act here. I think it is, clearly good practice to have an explicit reference to the European Convention on Human Rights in that regard.
No. Okay, how stands the amendment?
Pressed.
The amendment has been pressed. So we're on amendment number 5 and it's been pressed. So na ceachtaí atá Sunday ceiste abrigí tá.
Tá.
Na ceachtaí atá na gcuine abrigí níl. Is tóg bhfuil an cheist caillte. Now moving on to amendment number 6. Again, in the names of Deputies Paul Murphy, Breach Smith, Gino Kenny and Richard Boyd Barrett, arises out of committee proceedings. I talk to Paul Murphy.
Yeah, for me, this one and the demonstration test later are the two most significant issues for us and where we have the greatest problem. Section 10 is very, very problematic in my opinion. Section 10, and I read the transcripts of the committee debate, and the Minister didn't fundamentally deal with this. Section 10 creates the possibility of someone being criminalised purely for having material which is hateful, without that material being communicated to the public. That's a problem, in my opinion. That it gets to the fundamental problem of this bill. That is the creation of a thought crime. Someone has hateful material on their computer, they don't publish it, no incitement to hatred is caused, there's no consequence for anybody else, the person themselves has hateful ideas, they write hateful things to themselves, they download hateful material, whatever, and they can be criminalised as a consequence of that. Again, to be clear, I'm against this hypothetical hateful material that this person has on their computer, but I think it's extremely problematic to create this new category of thought crime, of preempting the incitement to hatred and the propagation of hatred ideas. And as a part of that, subsection 3 states that where it is reasonable to assume that the material was not intended for personal use, the onus will be put onto the accused to prove their own innocence by showing the material that they prepared, or even just material they possessed, was never intended to be publicly communicated. And so within section 10, you have the creation of thought crime, and then you have a dangerous reversal of the burden of proof, where the burden is now placed on the accused to show that, to overturn the presumption that the material was not intended for personal use. This is extremely problematic. There is a real problem in terms of civil liberties with this section. As I understand it, at committee, the Minister argued that, don't worry, the DPP won't be taking cases willy-nilly, it'll be very sensitive and so on. That can't answer to us as legislators. We're creating law. We don't control what happens after that, and we can't be satisfied by promises that the DPP will or will not do something, nor can we be satisfied by promises that the courts will or will not do something. We have to try and create good law, and I think this section, creating a thought crime, this is very, very problematic.
Thank you, Last Corley, and I thank the Deputy for his contribution. And the Deputy is correct. During the committee stage debate on this bill, this matter was discussed, I think, at length. This same amendment was proposed to delete Section 2 of the bill, which creates an offence of preparing or possessing material likely to incite violence or hatred against persons on account of their protected characteristics. The Deputies have again proposed the deletion of the section in its entirety, and I must reaffirm the previous stated position on this. It is fundamentally important to retain the latitude to prosecute an individual who has created content that would incite violence or hatred against vulnerable individuals or groups, but whose material has been intercepted before it is shared publicly. During the committee stage debate, a comment was made which equated the inclusion of this section as an attempt to legislate for thought crime. I have to thoroughly refute this assertion. An individual who has prepared a manifesto inciting violence against a group of persons with a protected characteristic or a social media post inciting dangerous levels of hatred against a minority group should still be held responsible for their actions, even if An Garda Síochána manages to intervene before the material becomes public. We have consistently strived to carve out the appropriate defences and protections for freedom of expression in this bill. As the Deputies will be aware, Section 10.2 of the bill expressly provides for protections that can be availed of. The first of these is intentionally wide in scope in that it allows for a defence to be utilised if the material that is in question consisted solely of a reasonable and genuine contribution to literary, artistic, political, scientific, religious or academic discourse. The use of the phrase reasonable and genuine contribution is the key to this provision. In the context of literary, artistic, political, scientific or religious or academic discourse, it allows for a contribution that is considered by a reasonable person, including a judge or jury, as being reasonably necessary in the context of a debate or discussion involving a protected characteristic. While it would not be acceptable to publish an explicitly racist paper which incites hatred, the defence of a genuine contribution to academic or political discourse could apply to a person who is genuinely researching a fascist group, for example, and is therefore in possession of material that could be deemed hate speech in the course of their research. The context is key here, and I am satisfied that this provision allows for a nuanced approach to its implementation. In summary, the inclusion of Section 10 is specifically to capture those instances where there has been a successful operation to stop communication of material or behaviour that clearly constitutes incitement to violence or hatred against a person or group of persons on account of their protected characteristics. These provisions do not apply to an individual who is preparing or possessing such material for reasons which are non-criminal. As with every aspect of this legislation, individual situations will be assessed by An Garda Síochána and the Director of Public Prosecutions to assess whether an offence under this section has occurred. As this preparation and possession of material offence already exists under the 1989 Act, it would be inappropriate to remove this provision, and to do so would inevitably result in persons that are clearly intending to incite violence or hatred avoiding prosecution in certain circumstances. For these reasons, I cannot accept the amendment. Thank you, Last Corley.
His answer kind of does get to the heart of the problem. He says that people should be held responsible for their actions, even if the authorities intervene before they do anything. How can you hold people responsible for actions that they haven't taken? That goes against like the main thrust of our criminal law, which relates to actual crimes that take place, not bad thoughts that people have and write them down. Like, that is a problem. I agree that, like, you know, the kind of manifesto, you can imagine, there's obviously multiple examples of them that you're talking about. I agree that the propagation of such a manifesto, inciting violence, etc., yeah, that should be an offence. But for someone to simply write such a manifesto and to have it on their computer and nobody else to see it, that's now a crime. Well, that will become a crime. That's a problem. That really is a problem. That goes against the basic idea that there have to be actions taken, and it's an action that is a crime. And like, the Minister, you know, objects to the notion of thought crime, but we're not talking about any actions here. We're talking about intervening before an action happens, and then, in fact, the burden of proof in terms of proving that this person, this hateful individual, the burden proving that they didn't intend to publish it, the burden is placed on them to prove that they didn't intend to publish it, rather than even being placed on the state to prove that they intended to publish it and we have simply intervened. So, again, like Minister is saying, people should be held responsible for their actions, but the only action we're talking about in this circumstance is someone writing down or downloading hateful material. and it not affecting anybody else apart from their own warped, hateful mind. But I think the idea that we should criminalise that, I really think that is extremely problematic, and unfortunately then undermines many of the good aspects of this bill.
Anyone else? Minister?
I think it's clear where somebody, an individual, has prepared documents with an intention to incite violence against a group of persons, and the Gardaí managed to intervene to stop that publication just before it happens, for example, that person simply should not be held in any way responsible for that preparation, what they've done. I think that will be inappropriate as well, and I think people will find that difficult. This is not the thought police. This is about holding people accountable and responsible where they have actively prepared documents with the purpose of inciting violence against a group of persons who we are aiming here to protect in their characteristics. Thank you, Concordia.
So, how stands... you want more? Yeah, we'll go on. If you want.
I mean, it gets to the fundamental issue again. We're just going around in circles. But this is material that is likely to incite violence or hatred. But this material can simply be sitting on a person's computer. No hatred has been incited. And, you're saying the Gardaí intervened before it's done, but the onus is then placed on the individual to prove that they weren't intending to distribute that material and therefore actually to incite hatred. So I think this is a serious enough infringement in terms of civil liberties and the right for people to have wrong, bad ideas and their own private thoughts and to write them down and to have them on a computer, and for that not to be an offence in and of itself.
How stands the amendment number 6 then?
Pressed.
The Choctaw ar Haven na Tarshkin na Sin British Tá. In a good Neil.
Yeah.
Stolum Gul Butcher in Kesh, but the question is defeated. Vote.